and today is day 23. Today we're going to be talking about Canadian Law Society's Artificial Intelligence Rules Compared, and in 2026 this is a guide for lawyers. Since ChatGPT hit the legal world, 9 Canadian law societies, 11 courts, 2 insurers, and even Canadian Bar Association have all weighed in one question. How should lawyers actually use artificial intelligence? Not one of them has banned it, but dig into the details and the rules are far from identical. Here's what's the same everywhere and what's genuinely different. First, the headline fact: every single Canadian law society that has issued AI guidance has landed in the same place: cautious permission, not prohibition. The Law Society of Manitoba was actually the first in the country to formally pronounce on generative artificial intelligence and give its guidelines. Now, strip away the formatting differences and you get 5 near identical themes repeated across every province's guidance on artificial intelligence. Number 1, competence now includes artificial intelligence literacy. Lawyers are expected to understand how a tool works well enough to know where it can fail. Number 2, confidentiality is a number one flagged risk. Every province warns lawyers about feeding client information into artificial intelligence tools that weren't built with solicitor-client privilege in mind. Number 3, judgment can't be delegated. Manitoba puts this most bluntly: professional judgment cannot be handed off to generative artificial intelligence tools. It stays the lawyer's responsibility always. Number 4, verification is non-negotiable, and we have spoken about this in many videos. Because of the hallucinated cases citations, every province stresses that AI-generated research has to be checked before it goes anywhere near filing. Number 5, the lawyer is always on the hook. No matter which tool was used, the professional responsibility sits with the human. Full stop. You as a lawyer, as a barrister solicitor, are responsible for all your actions. So functionality, seeing the functionality, these regulators all arrived at the same 5 guardrails, mostly independently. And now I'm just giving you a synopsis. Now here's where it gets more interesting. Because the shape of the guidance is where the provinces really diverge, Manitoba was the first, and its language is the most direct out of all. Ontario published a white paper back in 2024. It encourages experimentation, and as of April 2026, it explicitly does not require lawyers to disclose any artificial intelligence use to clients. Alberta went the furthest with a full generative artificial intelligence playbook, practical, operational, step by step. British Columbia leans on its existing professional responsibility rules rather than writing brand new AI-specific ones. Nova Scotia's December 2025 guide sets its tone with one phrase: curiosity and caution. And Saskatchewan has joined the growing list of provinces with its own formal direction on artificial intelligence. Here's the sharpest divergence of all. Courts are actually stricter than law societies. Manitoba's Courts of King's Bench has a practice direction requiring all lawyers to formally declare when AI was used in what documents and what materials were filed with the court. That's a harder line than anything the law societies themselves have imposed on lawyers. And this is not theoretical anymore. In Ontario, Mazahari versus Law Society of Ontario, decided in 2026, involved a lawyer whose AI-assisted court filings cited cases that did not exist. And Co versus Lee from 2025 is another Ontario case flagged in for AI hallucination issues. So here's the real takeaway on the big principles: competence, confidentiality, verification, non-delegable judgment. Canada's law societies are remarkably unified and have given out very easy rules for AI, but on how strict they are about disclosure and what happens when it goes wrong, the picture is about to get more fragmented. If you're a lawyer practicing across provinces, or even just using artificial intelligence tools on a day-to-day basis in your practice, you can't assume one's province's comfort level to another. The state of AI regulation in the Canadian legal profession as of 2026 once shared instinct several very different rule books, each for a different province and each for the different court. All of the sources and the links to the AI competence documents I have mentioned are all in the description below. Please go check out your own Law Society guidelines directly, and the link is all in the description below. Thank you so much. If you found this helpful, please do let me know in the comments of which Law Society's rules do you think are the most reasonable and make the most sense. But this video was just an approach to give you those 5 major a few points which each Law Society has. Do subscribe to the rest of the series. Thank you and have a great day.